Recording in progress.
Yes. Baik, terima kasih. Izinkan kami dari Humas untuk yang dapat info. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan selamat sejahtera yang kami hormati Bapak Ibu pengunjung sidang, yang kami hormati rekan-rekan media, kemudian juga hadir bersatu dengan Bapak Ibu penuntut umum. Ini kita sampaikan dulu di awal karena nanti hari ini acara putusan perkara nomor 202 putus atas nama Haris dan perkara nomor 203 atas nama Fatia-Haris. Ya, tentu kita sepakati dulu karena persidangan tentu ada tata tertib.
So there are some regulations according to the Supreme Court regulation regarding the protocol for court proceedings and security in the courtroom.
Dan keamanan dalam lingkungan persidangan.
We would like to let you all know
Tentunya kami sampaikan pada Bapak Ibu
that in Article 4,
dalam pasal 4
each visitor in the court
setiap pengunjung yang masuk ke pengadilan harus melalui satu akses dan
single
mengisi buku tamu
access
serta
and
menukarkan
must
kartu identitas
register
dengan kartu
using a
pengunjung.
valid ID card. Each
Kemudian dalam ayat 2-nya setiap
person
orang dilarang membawa senjata api,
must not bring
senjata tajam, bam peledak atau alat
weapons,
benda
explosives,
apapun
and
yang dapat
anything that
membahayakan
will
keamanan sidang kecuali
endanger the
aparatur
court.
keamanan yang bertugas.
Article
Kemudian
5,
dalam ayat 5, setiap orang yang hadir dalam ruang sidang
each
wajib
person in the
menunjukkan
courtroom must
sikap
be
hormat
respectful
kepada
of the
pengadilan.
court.
Ayat
Article
6-nya,
6,
kemudian
audio
foto, rekaman
recordings,
audio,
audiovisual
dan rekaman
recording
audiovisual
must
harus diizin
have the
dari
permission of the
ketua
judge
majelis
prior
hakim yang bersangkutan dan
to
dilakukan sebelum
the
dimulainya
court proceedings.
Kemudian
Article
dalam
8,
ayat 8-nya,
Visitors must not converse with each other, eat, smoke, or anything that will disrupt court proceedings. Each person in the courtroom must not use their cell phones for communication and keep it on silent throughout the court proceedings. Article 10. Visitors must not make noise which will disrupt court proceedings. Article 12. Visitors must not exit and enter the courtroom which may disrupt the proceeding. Any brochures, banners, etc. must not be displayed without written permission from the judges panel. Each person must be dressed appropriately and wear the proper footwear. So those are the rules due to the capacity of the courtroom. The plan was for 50 people in the courtroom, but now we have more than that. So those of you who are standing, my apologies. I have advertising. You can also follow this proceedings through the YouTube streaming channel, so you can view the proceedings on YouTube. We also have television monitors outside if it is not possible for you to enter the courtroom due to the capacity limitation. Any questions from mass media?
Itu kamera khusus yang di sini ya. Mass media nasional tuh di belakang baris ya. Demikian ya. Ya.
So prosecutors, we see you have 12 prosecutors. We'll give up a chair to the defendant team. So we should have 12. We should have 12 people on both sides. To the courtroom clerks, can you assist us with that?
Memang jumlahnya yang hadir yang di belakang tidak.
So how many people from the defense team do not have a seat? So we shouldn't have too many people in the defendant's team.
Iya, betul, silakan ya. Betul.
Because we have enough people on the prosecuting team, so they giving up some chairs for the defense team, so you can all sit. Anything else? We have 1, 2, 3. Just one moment.
Masih ada lagi yang lain? Cuman 1, 2, 3, 5. Sebentar Pak, jangan. Sebentar Pak ya. Tambah kursi Bapak ini jangan.
So the judges will decide on the number of seats you can have. So we have from public relations, we are just facilitating. We don't have all the prosecutors team here, and you have more people in the defense team than usual. So as public relations, I am just informing you of the rules of engagement. So I hope that's clear. I hope everybody's clear. Visitors, if you feel uncomfortable standing, you can wait outside. We do have monitors outside, and you can watch it on our YouTube channel, on our live streaming. So we hope that makes it easier. I hope that's all. I hope it's clear for everyone. Please adjust accordingly to the TV monitors.
Mempermudah ya. Cukup dari pengunjung, cukup dari rekan-rekan media, cukup. Ya, silakan menyesuaikan posisi layar elektroniknya.
So that's all from me. We have more lawyers on the defense team than usual, so the judge will accommodate
Ya, nanti dulu Pak ya.
the numbers, and that's all from me. Thank you.
Sehubungan dengan jumlah tim penasihat hukumnya melebihi dari yang biasa hadir, ya tentunya nanti majelis hakim akan menyikapi sehubungan dengan permintaan dari tim.
Ladies and gentlemen, please rise for the judges.
Terima kasih.
Hadirin dimohon berdiri, majelis hakim. Hadirin dimohon duduk.
Ladies and gentlemen, please take your seats.
Tapi dari terdakwa itu kan sebatas itu memang ya, kalau itu pun kosong itu kan nggak bisa di switch seperti itu ya. Tolong sekali Kak, supaya tertiban persidangan ini, tolong sekali supaya yang ya itu aja, supaya di pengunjung boleh ya, itu aja. Iya ya, nggak usah. Lalu saya konsultasi dulu Pak. Saudara, itu cuma kelengkapan berkas saja, ya. Itu tidak ada kaitannya dengan ini, hanya kelengkapan berkas, ya.
Apakah lebih baiknya tidak perlu itu, Pak?
Enggak, itu hanya kelengkapan berkas. Kita menerima berkas itu ada menunjukkan itu di SPP diatur di situ.
Iya.
Kelengkapan berkas.
Itu
Kalau kan kita udah ikuti semua. Ya. Kalau nggak mau nggak apa-apa. Maksud
saya kita tidak tahu itu. Kita pengen bantu Bapak.
Kita izin nih.
Ya.
Atas nama saya sama Fatia.
Ya.
Konsultasi begini. Ini kan jadwal judulnya kan rencana kerja Pak.
Kita nggak masalah dengan
ya itulah.
Kami sebenarnya
Sudah di
sama-sama ini
SPP
nggak
seperti
keberatan.
itu. Tidak masalah.
Tapi kan pada prakteknya
Iya.
lebih lama.
jadi nggak Bapak nggak perlu khawatir ya.
Ada seperti ini itu tidak akan bisa tidak itu kelengkapan
yang di sini ya.
Ya, cuma kelengkapan saya, tidak masalah. Ya, semua perkara seperti ini.
Iya.
Terus ini
Semuanya di.
Iya, kita semua cuman
berapa nih Pak?
kurang precise saja.
Sekarang tanda tangan aja kan sudah.
Ini udah nih. Gue udah nulis tanggal.
Ya, ya. Ya, tidak masalah.
Ini bukan siapa?
Are we ready?
Sudah siap? Sebelum kami akan membaca, minta
We will request
tempat duduk hanya disediakan seperti ini, ya.
So we have prepared these
Awal persidangan kita
limited number of seats in the beginning of the proceedings.
sampai ada penasihat
We did not allow
itu aja. Silakan
any member of the defense team to be standing in the courtroom.
ruang pengunjung dan sebagainya. Ya, ini sudah terwakilkan semua.
I believe you have enough representation here. I'm sorry, my feed is lagging.
Supaya tidak untuk menjaga ketertiban
So
kelihatan
we want to maintain order in the courtroom. Well, so we believe that you have proper representation because we want the courtroom to be orderly because this is the last
maaf ya,
court session
kesediaan JPU untuk memberikan tempat
and the public prosecutor has allowed us, so we beg for your understanding.
hal seperti itu. Karena ini memang kapasitasnya seperti ini. Jadi sama-sama 12 tempat duduk. Jadi tidak
Because
sama-sama
there
memang-
is
memang
some empty seats, the public prosecutors have
seperti ini.
allowed
Jadi
it,
sama-sama 12 tempat duduk. Jadi tidak
but this is the capacity that it is, so we have 12 seats on each side, so we cannot switch the empty seats from the public prosecutor side to the defendant team.
Majelis nanti mungkin bisa bergantian jika ada waktu tertentu.
So we ask that none of the defense team is standing in.
bisa bergantian. Nanti mungkin
Please move to the visitors area.
bergantian dengan teman yang ya silakan. Saudara.
Perhaps we can take turns. Okay, you can take turns.
Sebelum keputusan ini dibacakan, ya lagi kepada semua pengunjung yang ada di ruang persidangan ini agar menjaga
Before
ketertiban, ya.
we read this out,
Mari kita saling
the verdict,
menghargai supaya bisa
we ask all the visitors to
baik dan lancar apapun
maintain order.
semoga
So in order for everything to run smoothly, whatever the verdict may be, We want this to be the best for everyone. Please, everybody, maintain order and do not disrupt the proceedings. If you are disruptive, we ask for you to leave the courtroom before we read the verdict. We would like to inform both sides that this case, there are two cases that have been split. There are two cases. Therefore, our opinion is that we will read the verdict because it's a split case. But the witnesses, the charges, etc., are the same. So in this case, we ask that the reading of the verdict will be done simultaneously, will be opened together for both Haris and Fatia. It will be open and read simultaneously. So we will not duplicate reading the same thing. Any differences we will read separately. Can we agree on this? And I will read this verdict, but not in its entirety. You can see how thick it is. And I will not be reading the charges because it has been read out. Witness testimony will not be read because it is contained within this verdict. Anything else? Evidence and expert testimony will not be read because it is contained within this verdict. That's it. Is everybody ready? Yes? May I obtain the verdict in full? Yes. So after you have banged the gavel 3 times, can we have a copy of the verdict? So we will not wait several days for that. So for the final verdict, we will read one at a time. We will read the differences. No, I'm just asking for a physical copy. Yes, yes. Yes, you will receive it today. Today? Yes. Court proceeding for the case 202 in the East Jakarta Court. The defendants Haris Azhar and the case registered 203 Pitsus 2023 East Jakarta Court in the name of Fatia Maulidianti is hereby open and is open to the public. You both well today?
Decision number 202, Special Crimes. 2022, East Jakarta. For justice based on the belief in God Almighty, the East Jakarta District Court trying this case based on the ordinary proceedings have arrived at the decision as follows. For the defendants, Haris Azhar, born in Jakarta, 48 years old, born July 10th, male, Indonesian, residence Bawal Street, Pulau Gadung, East Jakarta, Muslim, professional lawyer. Next, the decision number 203, Special Crimes 2022, East Jakarta, for justice and in the name of God. The proceeding have arrived at the following decision. For the defendant, Fatia Maulidianti, born in Bogor, 30 years of age, female, Indonesian, residence in Tanah Serial, City of Bogor, or a different address also in Bogor, Muslim, private employee. In consideration of there's no detention for the defendants and the fact that they are also being represented by legal counsel Asfinawati et al., who are advocates, public defenders, assistant public defenders, joined under the Team for Democracy, located at the Diponegoro number 74 Street, the district court, after reading the briefs, for the cases number 202 and 203, and other relevant documents, and after listening to the testimony of witnesses and experts, also the demand from the prosecutor, essentially, which will not be recited here, and to be considered to have been read, in consideration that the requisitory by the public prosecutor, in response to that, the defendants have provided with a note of defense, also will not be read out here and is to be considered to have been read in court. In consideration that in response to the note of defense by the defense and the defendants, that will not be read out here, have received a response from the public prosecutors, which in turn have been responded to by the defense, the contents of which will not be read out here. In consideration that the defendants were submitted to court based on the indictment letter number so on and so forth, which was read in March as follows. First, the defendant Haris Azhar and so on and so forth will not be read out here and is to be considered to have been read in session, have violated Article 27, Paragraph 3 of the Electronic Information Transaction Law in conjunction with law of the Criminal Code, Article 55. Primary charge, Article 17, in conjunction with the Criminal Code, subsidiary Article 15, in conjunction with Article 55 of the Criminal Code. The third,
Pasal 310 ayat 1 KUHP Yungto pasal 55 ayat 1 ke 1 KUHP.
Next, during the proceedings, the public prosecutor have presented some witnesses which will be read out here. First, witness Luhut Binsar Panjaitan, Widianto Adi Danar Kusumo, Dwi Partono, Khairul Sahari, aka Heru, Melissa Deborah, Paulus Prananto, Agus Dwi Prasetyo. Again, experts Asisda Wahyu Asri Putradi, Roni, Professor Agus Surono, Heri Priyanto, Major General Heri Wiranto. Witnesses from the defense are witness Ahmad Asof Biri, Muhammad Iqbal Damanik, Wahyu Agung Perdana, witness Dami Zanambani, witness Tobias Bagubau, and witness Johan Songgonau. And then experts presented include Antonius Madetoni Supriyatma, Yunus Hussein, witness Rocky Gerung, witness Herlambang, witness Makyun Subuki, Mas Ahmad Santoso, Ahmad Sofian, and Faisal Batubara. And then we'll go to the physical evidence. The physical evidence presented by the prosecution and by the defense are contained in this decision and is to be considered to have been read without being read at this moment. Next, we will go straight to the consideration of the panel of judges in this case, which will be read by member of the panel number 1. In consideration that the judges will consider whether they are culpable to the crime as was indicted by the prosecution against the defendant before considering the elements of the offense, we need to go back to what is the case. There is the case from the research by the civil society regarding the protection of the environment conducted by YLBHI, LBH Papua, Greenpeace, Pustaka Bendara Rakyat, Trend Asia, and Jatam together in the hashtag Bersihkan Indonesia produced a study regarding the economic politics, the deployment of the military in Papua and Intan Jaya that was broadcast by Fatia-Haris and Haris Azhar and another individual representing the civil society, representing the Walhi Papua on the YouTube channel with the title of Luhut Behind the Politic Economies, and that podcast have came to the reporting party, and then Luhut Binsar Panjaitan took issue, assuming that it is discredited him, and then that's why he, through his legal counsel, issued a cease and desist letter and then requested for a meeting or a mediation, but because there was no apology from defendant Haris Azhar for the content of the broadcast of said podcast, then Luhut Binsar Panjaitan reported him to the police for defamation. In consideration that the focus of the examination has been the quick study by the civil society to the podcast regarding the deployment of the military in Intan Jaya, and then the letter against the defendant and the responses from Haris Azhar, and then the report against Haris Azhar at the provincial police headquarters. In consideration that the defendant has been charged in indictment in combination of alternative and subsidiarity, that has provided us with the discretion to choose the charges, but it's a fait accompli because it is as though we have to choose, and what we choose is right. In consideration that for the fair trial principle, the panel of judges will consider the charges systematically from charges number 1, 2, and 3. Charges number 1, Article 27, in conjunction with the Criminal Code, the law on the electronic information and transaction has been changed in 2016 in conjunction with Article 55 of the Criminal Code, with the elements as follows. The first, every person. Number 2, distribute and or transmit and or make accessible electronically. Third, containing defamatory contents. Number 4, with intent and unlawfully. Number 5, together with a person who is committing the crime. In consideration that every person means a legal subject, human person or legal persons who could be held accountable, criminally liable for the outcomes of their actions, and because that is in line with the definition of person and the law of electronic information and transaction as was changed in 2016 regarding electronic information and transaction, which henceforth will be EIT law. It is the Indonesian citizen or Indonesian corporation. And Haris Azhar has been the defendant on file, as well as defendant Fatia-Haris. Their identity has been verified by the defendants, and there's no other individuals before this court have appeared except the two defendants, in consideration that they are competent, mature, accountable, healthy, physically and mentally, responsive to the questions, responsive to the examination regarding their actions. They have met the requirement as defendant in this court. Based on that, this element is met. Element number 2, to distribute, transmit, or make electronically available, in consideration that distributing, transmitting, or making electronically available, it is an element that could be cumulative or alternative based on the facts. And based on the ITE law, there's an explanation that to distribute or transmit or making electronically available means to distribute, to disseminate electronically to many people, many parties through a electronic system. Transmitting means sending electronic information or electronic documents to another person through electronic means. Making electronically available is any other means of making the electronic information or document be made known to another person. And the explanation says that electronic information is a set of electronic information that is not limited to pictures, words, IDs, emails, telegrams, and the like, letters, markings, symbols, perforations that have been processed, that have meaning, could be understood by a person who could understand them. Based on Article 1, Paragraph 4 of the ITE law, electronic documents mean every information electronic that is sent or received, stored, analog, digital means, or the like, that could be viewed, displayed, heard through the computer or electronic systems, including but limited to audio, pictures, maps, designs, pictures, letters, markings, symbols, perforations that have meaning and can be understood with the capability to understand them. And in consideration that, based on the proceedings, the defendant on that date at the office of Hak Asasi.id at Balai Pustaka Street in Rawamangun, East Jakarta, using the YouTube account, which is an electronic means, have produced an electronic document, which is a podcast file, with the title, There's Lord Luhut Behind the Politics and Economy of the Military in Intan Jaya, with a duration of 26 minutes, 51 seconds, a conversation with Fatia Molidianti and another individual, people working in civil society in the field of human rights and the environment. Bearing in mind that Haris Azal is the owner, person in charge of that channel, have provided the consent authorization for the witnesses Agus Dwi Prasetyo for the uploading to be done and to approved for the publishing of that content. So that action of uploading and publishing of the podcast done together with the team is a process that is structured and premeditated, and it shows and proves that this element is proven and established, that the process of publishing and distribution is a form to broadcast the content to the public more widely, where people with electronic connection can receive and view. So Haris Azhar and his team, by uploading and making it public by publicizing it, making it more accessible to the public, directly establishes the element of transmitting, distributing, or making electronically available in the EIT law. In consideration that Haris Azhar, in his note of defense, admitted to have posted on his account his conversation with OE and Fatia Mulyadianti, the information based on the research, explicitly illustrating the threat to the forest and the environment. So this element is now proven and established. The third is content that is defamatory in nature, in consideration that the element of containing defamation in the EIT law is inseparable from the or connected with the Constitutional Court decision in 2008 and the explanation of Article 27, Paragraph 3 of the ITE law and the joint decree from the Ministry of Information and Informatics and the AGO in 2021 regarding the guidelines for the investigation of crimes under the ITE law.
Selanjutnya disebut SKB nomor 229 tahun 2021, nomor 154 tahun 2021, nomor KB 26 Romawi
Considering
2021.
that with the circular
Bahwa berdasarkan SKB
of
nomor
2021,
garing nomor 154 tahun 2021,
in 2021, we are declaring that A, based on the considerations in the Supreme Court ruling number 50 of 2008 and the explanation of Article 29, Part 3 of the ITE law, defamation refers to, and it is inseparable from the provision of Article 310 and 311 of the Penal Code. This attacks a person's dignity in the public. Article 311 of the Penal Code is accusing someone where the accusation, where the perpetrator knowingly knows that it is untrue. According to the law number, according to this, we can come to the conclusion it is unlawful if the content being transmitted has been made accessible. It is defamation, it is slander, and is inappropriate. And this act can be qualified as defamation in Article 315 of the Penal Code. With the amendments to the law in 2008 and the Supreme Court decision is not part of the reference in this law, this ITE law. The offense of defamation in Article 22 of the ITE law, if the content being transmitted is being made accessible, is opinion based on evaluation or as a statement. D, in the fact being alleged undergoing this legal process, the fact must be proven before law enforcement processes the complaint of defamation according to the ITE law. Offense number Article 22 is an absolute offense according to Article 45 of the ITE law. As an absolute is a reportable offense unless the reporting party is underage. With regard to the conversation and statements by Fatia and Haris Azhar in minute number 14.23 to 14.33, it said that Lord Luhut He is involved in mining in Papua in minute 18.00 to 2200 as stated. So we are criminals too. In the charges from the public prosecutors, the witness Luhut sent a cease and desist order. The wording Lord Luhut in the podcast, the accusation that he's involved in mining operation in Papua, and the third statement that we are also criminals. The report filed by witness Luhut Panjaitan, the witness objects to the wording Lord Luhut and Luhut being involved in mining operations in Papua, and there is no statement of objection to the statement we are criminals also. And the witness does not remember that statement in the podcast, that in the charges, the public prosecutors places emphasis in the defamation content contained in Lord Luhut in the title, not from the conversation between Haris Azhar and Fatia, and the sentence of being a criminal as well. And in the sentence that we are also criminals. The word Lord being affixed to the name Luhut is often used in the media. If people say Luhut bin Sar Panjaitan, even in daily conversation, the word Lord Luhut is often said but does not end legal proceedings. This is a word given to somebody who has authority, is a leader, or is person in power. The affixation Lord before Luhut is not personal, it is more to their official position as a minister in the cabinet of Joko Widodo, and he has been entrusted by the president to handle governmental affairs and in emergency situations such as during COVID-19 in Indonesia. Considering that, therefore, the judging panels considered the wording Lord Luhut is not intended as slander or defamation because the word Lord does not is not derogatory, it is not referring to a person's physical attribution, but rather the position of that person. Considering that the phrase that we are also criminals said by Fatia Maulidianti in the conversation in minute 1800 to 2200 is conversation between Fatia and Azhar regarding the mining business involving three companies, Antam, FT, and Toba Sejahtera, whereby Haris Azhar engaged Fatia to take over the companies involved in mining, but Fatia replied with the sentence, "We would then be criminals too." And this was a joke. The wording, "we would then be criminals" also in the context of the conversation Haris and Fatia were related to the three companies that have mining involved in the mining business does not refer to witness Luhur bin Sar Panjaitan. Therefore, Luhut is not related to Antam or FBC, so therefore, the judging panel feels that Fatia's statement does not refer to Luhut, but is in reply to Haris's suggestion that she take over the companies. The judging panel is in their consideration of Luhut's involvement in mining Papua, considering that the basis of the examination in this case is the charges from the prosecutor that reviewed the conversation of the podcast in the quick study by Civil Studies as defenders of human rights and the environment that are examining the mine activities that disregards destruction of the forest and social impact. Fatia's statement in minute 13.10 to 14.33. That's it. But behind this, we have the name Toba Mandiri, which is a subsidiary of the Toba Sejahtera Group. Therefore, the Toba Komdel Mandiri's director is Paulus Prananto, as an ex-military. We know that the group is owned, the shareholders belong to one of our officials in the name of Luhur bin Sarpanjaitan. Lord Luhut, so you could say that he is involved in mining occurring in Papua today. Which statement refers to the quick study in pages 17 and 18 that states that Toba Sejahtera Group belonging to Luhut bin Sarpanjaitan has an alliance for mining in the project with Wits Mining, considering that witness Luhut bin Sarpanjaitan in the court proceeding admitted to being a shareholder in the company, but is not a shareholder in Toba Mandel, which is a subsidiary of the company, and since holding official position, the witness has entrusted Nana as a professional to manage the companies belonging to the witness, considering that with the ownership and the shareholders in Toba Sejahtera, mutatis mutandis, the company receives benefits for Toba Mandiri as a subsidiary, and indirectly, Luhut is a beneficial owner of Toba Komdel Mandiri, considering that in page 118 to 204, in accordance with the charges from the prosecutor, pages up to 331, has expressed the currents between Toba Komdel Mandiri and Toba Sejahtera and Wits Mining, which shows a correlation to conduct a mining business between the two parties, considering that although the witness Paulus Parananto attended the meeting in a personal capacity, it does not negate that the witness Paulus Parananto uses the facilities of Toba Komdel Mandiri in conducting this activity, and other parties consider Paulus not in his personal capacity, but rather as a capacity as the director of PT Toba Komdel Mandiri, which is a subsidiary of Toba Sejahtera, whereby 99% is owned by the witness Luhut bin Sarpanjaitan. Considering that the consideration above, Fatia's statements relating to Luhut, it could be concluded that Luhut has a role in the mining in Papua cannot be denied because it is proven that Toba Komdel Mandiri, as a subsidiary of Toba Sejahtera, whereby 99% of the share is held by Luhut bin Sarpanjaitan, has business with Wits Mining to conduct mining enterprises in Papua, referring to the joint circular from the Ministry of ITE, AGO, and Indonesia National Police Chief of 2021 regarding utterances within the articles of ITE as amended. Therefore, the panel of judges considers that the conversation to Haris Azhar and Fatia Maulidianti and Owi cannot be included in the category of defamation or slander because this was a commentary, an analysis, opinion, and an assessment of the outcomes of the quick study from Civil Society Alliance. As considered above, the statement that it can be concluded that Luhut is involved in mining in Papua, and the sentence we'd also be criminals, which is not included in the material in the complaint of Luhut to the police, cannot be considered to be defamation. Therefore, this element is not fulfilled according to the law. Since the third element is not fulfilled, they are not proven to have not proven to conduct this criminal, and they must be acquitted. The second alternative, in their conduct against the law in the criminal code. Whosoever broadcasting news or incorrect information or causing public unrest, and those who conduct this providing instruction to this, considering that the element, consider this element, it has the same definition as whosoever. We are considering this element in the first charges, which has been fulfilled by law, to be applied in the consideration of whosoever in these charges in accordance to the guidelines in page 208 of the Supreme Court's verdict of the year 30 June 1995. In its consideration states the terminology whosoever as anyone, and this must be used. This is a person who is the defendant who is accountable for their actions. But the consequence of the ability to be accountable does not need to be proved again, because each subject of the law is accountable as stated before.
So based on the report to the provincial police, there are two things that are reported by the witness Luhut against the two reported persons. First, Fatia, second, Haris, with the contents as follows. The first, that the actions of reported person number 1 is the statement in the minute number 44 that, you can say that Luhut is playing around with mining in Papua these days. Number 2, the report is about the title, that there is Lord Luhut behind the economic, military, and Intan Jaya. There are also been generals. In consideration that the quick study of the Intan Jaya case as the reference of the conversation between the three people on the podcast states that there's the interest of the witness Luhut as a person who is part of or involved in Tobakom del Mandiri, and also the witness Luhut acknowledged that he holds shares of Toba Sejahtera but not an owner of Tobakom del Mandiri, and the witness has entrusted the running of the company professionally, and in consideration that with the ownership of the shares, then automatically Toba Sejahtera obtains the benefit from the operations of Tobakom del Mandiri, because there is an annual report from the subsidiary to the main company. This is in line with the note of defense, saying that there is a conflict in correspondence between Tobakom del Mandiri. It shows that there is a correlation to conduct mining operations between the two, even though Paulus Putrananto said that he attended the meeting in personal capacity, but witness Paulus has benefited from the facility provided by Tobakom del Mandiri, as indicated in page 198 or 137 of the note of defense. In consideration that examining the address of Tobakom del Mandiri in the minutes of meeting, that is the same as the address of Tobacco Mandiri shows that Paulos Fernando has attended the meeting in official terms, even though he denied that by saying that he attended the meeting in a personal capacity. In consideration that, according to the above, then the statement by Fatia that we can say that Luhut is playing around and mining in Papua these days is something that it cannot be denied because it is proven that Tobacco Mandiri, as a subsidiary of Tobacco Sejahtera, has engaged in the business dealings for the Derewa project. And also considering the witness or expert Wiranto that the operations Papua is a security operations that assigns the commander in chief of the military to conduct operations. There's a plan to deploy more troops in Papua, and also the witness Nambani, who showed that there is an escalation of the presence of the military. Also, witness Tobias explaining the operations of mining in the area, and also the witness Haris tried to meet with witness Luhut, who did not eventually meet. It has a correlation between the security of critical infrastructure with the deployment of the military in relation to the presence of armed criminal groups in the area. That the deployment is to protect the operations, in this case mining, as also contributors to state revenue because of the threat of the armed criminal groups would affect failure to do so would affect in the decline in investment in Indonesia. These things were mentioned in the quick study by the civil society, the relationship in business terms, and its relationship with the military operations, and the effort by witness Luhut to maintain the investment climate, and in consideration that according to the quick study that shows the involvement of witness Luhut as the senior minister, that is the point of the conversation, then the judge does see a connection between that and the title of the podcast. So the conversation with the title is still within the expected corridors, and consideration that from the above, especially in regards to the involvement of witness Luhut in the mining operations through subsidiary of Tobacco Mandiri as the shareholder, because 99% of the shares of Tobacco Mandiri is owned by Tobacco Sejahtera, and as a senior minister, and as mentioned in the quick study, is not blind to, or this is not a hoax or a misinformation, because this is something that has been studied by the civil society in this quick study and mentioned by Fatia Maulidianti regarding the involvement of 3 companies in mining, which is Antam, Freeport, and Tobacco Mandiri, subsidiary of Tobacco Sejahtera. So this element is not proven against the defendant. And because these things are not proven, then the second charge is not proven, it's not established, and with that, the defendant should be released. Next will be read by member number 2, member of the panel number 2. In consideration that the panel will now consider the second alternative charge based on the criminal code with the elements as follows: every person distributing or disseminating exaggerated or untrue information, or that they could or should suspect. Number 4, those who instruct or are aiding and abetting, that is in the element of every person or whoever has the same consideration with the consideration of the same element in previous charges. We are taking the same considerations for this charge as well. In consideration that for this element is also been met. So we move on to the second element, which is to disseminate untrue or not incomplete information. That Tambang Sejahtera, Tobacco Del Mandiri is a subsidiary of Toba Sejahtera. That 99% is owned by the witness Luhut Binsar Panjaitan, and the witness Luhut every year is given the annual report of Toba Sejahtera that he entrusts in the running to the CEO and has meetings on a regular matter with a frequency of 3 times per year. So in the minutes of meeting, dated October 5, there is a commitment, there is an agreement between TDM and Madinah Kuratain with the terms of MQ providing 30% of the shares for a certificate of clean and clear that is given by the Energy and Mineral Resources for the concession, also for the security of the area for the Derewa project, that the business alliance between TDM refers to the Australian Stock Exchange media release regarding the Derewa project, that the podcast video between Haris Azhar and Fadia Mulidianti and Owi is a conversation about the outcome of the study by the civil society comprising 9 organizations in the field of environment and human rights. The quick study is conducted based on the documents that was uncovered, including the minutes of meeting in 2019 and also in 2017, that the Australia Stock Exchange announcement and media release of 2016 and 2017, the meeting agenda for the Derewa project, the agreement in July 2017, and email with Switch Mining to the Toba Sejahtera in 2018. Considering that from the facts above, especially with regards to the ownership of 99% of the shares of Toba Sejahtera by Witness Luhut and the agreement with Westwich Mining and Tobacco Del Mandiri, which is a subsidiary of Toba Sejahtera, then Toba Sejahtera is obtaining a benefit from the business alliance, where the Witness Luhut is the beneficial owner, the owner of the benefit, because also he, on a regular basis, obtains the reports, both annually and tri-monthly, regarding the situation of the company. Considering that based on the above, then the element of unsure information, exaggerated, incomplete, has not been proven for the defendant Haris Azhar and Fatia Molidianti. And because this element has not been established against the defendant, then the second charge alternatively is not proven, and the defendants should therefore be released. In consideration then that we will now consider the third charge based on the criminal code, which has the elements as follows. Every person infringing on a person's dignity or reputation by spreading false information to the public. In this case, the first, the element of whosoever, because this element also entails the same considerations in the previous elements. We are taking the considerations from the previous charges in whole for the consideration in this charge. And then in consideration that this element has now been established. Number 2, defaming, attacking their reputation with false information in relation to the report by Luhut Binsar Panjaitan in 2021 to the Jakarta Police regarding the podcast is about two things: that the action of the reported person is the statement in minute 44 that Luhut is playing around in mining operations in Papua these days. And then the second action is the titling of the video. There's Lord Luhut behind the economic military operations in Intan Jaya. There are also bin generals. Considering that, based on the above considerations, that there is a business alliance between Westwich Mining with Tobacco Del Mandiri, that is the subsidiary of Toba Sejahtera, which 99% of the shares is owned by Luhut Binsar Panjaitan, and there's a coalition in business between Antam, Freeport Indonesia, and Toba Sejahtera in the managing of mining in Papua. It is shown that Luhut Binsar Panjaitan is the beneficial owner and directly obtaining benefit from the operation. Also, because of the annual report reporting the operations to the board of directors, and an activity of the subsidiary is something that is reported in the annual financial report of the company. And therefore, the phrase Luhut can be said to be playing around with mining operation in Papua these days is not about playing a game, but the indirect interest that he has as the shareholder, 99% at Toba Sejahtera Company, where Toba Sejahtera is the owner, 99% of Tobacco Del Mandiri, that is engaged in a business alliance with Westwich Mining. And that the relationship, the correlation of military personnel is to secure the operations there against the threat of armed criminal groups, trying to maintain the investment climate. Number 5, that these things has been presented in the quick study by the Coalition of Civil Society, the relationship between business and mining, and the presence of the military in Intan Jaya, and the role of Intan Jaya as the senior minister to maintain the investment climate, and also his personal interest in the company. And after he was inaugurated as the acting Minister for Energy and Mineral Resources in August 16 of 2016, has replaced Archandra Tahar. Also in consideration that in the quick study that contains the information regarding the involvement of witness Luhut, the point of the conversation there is the correlation also with the title, so that between the conversation and the title, they're still connected and within the corridors, except the phrase, there's also been BIN generals. So according to the panel of judges, what is being discussed by Haris Azhar and Fatia Mulyadianti is not something that defames or insults, because it is a fact that has been established based on the documents and testimony evidence in court. And because this element is also not established, we can say that because the element has not been established against the defendants, the alternative number 3 is also not proven, so the defendants, both of them, should be released from the indictment. In consideration that all of the indictment has not been proven, so the judges say that the defendants have been proven to not have committed the crime. I can repeat that because all of the charges by the prosecution, then it is the basis for the judges to not convict the defendant in charges number 1, number 2, and number 3. Considering that because of the indictment is not been proven, then according to the Criminal Procedure Code, then the defendants are considered acquitted. In consideration that according to the provisions of the government regulation, then defendants are given rehabilitation in the form of a restoration of their name, reputation, and dignity, that of all the physical evidence will be decided as follows. Because the defendants are acquitted, then fees are borne by the state. That we appreciate all the parties that have been involved in the examination, both investigators, also prosecutors, also the court, the bar, and the visitors, including the military and the police personnel who have helped secure. And the debate within the courtroom is something that is normal, but we need to heed the saying of our parents that we can be heated in the heart, but be cold in our minds. That we also need to consider the actions of the defense who refuse to listen to the Crown witnesses' statements but still included their statements in the note of defense. To refer to the Latin phrase, which means no person should be punished for what they are thinking. This is in line with the statement of Rocky Gerong as one of the experts. So considering that the unitary state of the Republic of Indonesia as a democracy, we uphold the freedom of thought, freedom of opinion, freedom of expression as the fundamental right of every person, as is enshrined in our Constitution. Considering that to be a public official in a government must be ready to be criticized against their person or their performance, even the President Joko Widodo has been criticized, insulted for his physicality, intellectuality, and performance, but he is still humble and has dismissed all of them. May God continually protect him. In consideration of the provision of 9191 of the Criminal Procedure Code and other relevant provisions,
Very well. I will now, excuse me, I will now read the verdict. Stating that the defendant Haris Azhar has not been proven legally and beyond a reasonable doubt to commit the criminal acts as charged by public prosecutors in the primary charges, the two subsidiary charges, and the third charges. Second, Haris Azhar has been acquitted of all charges. Third, returning their rights in their status, their dignity, their reputation, and the evidence, the physical evidence from physical evidence 1 through to 107. My apologies, my feed is buffering.
Demikian diputuskan dalam rapat pemusyawaratan Majelis Hakim pada hari Kamis tanggal 4 Januari 2024 oleh kami Cokorda Gede Artana SH MH.
The cost of the trial will be paid by the state. This is our verdict on Thursday, 4th of January 2024 by Cokorda Gede Aparna as the chairman of the panel, Ari and Agam Sharif Bahudin as members of the judging panel, stayed on Monday, 8th of January 2024. in proceedings open to the public with the support of Asmi Azhar, attended by Sandi Hadika, public prosecutor in the East Jakarta
Amar putusan untuk
court,
saudara Fatia.
and also the defendant's
Satu, menyatakan terdakwa
defense
Fatia-Haris
team
tidak terbukti
present.
bersalah dan meyakinkan bersalah melakukan tindak pidana sebagaimana didakwakan penuntut umum dalam dakwaan pertama,
Verdict for Fatia
primer, dakwaan kedua,
will now be
dan dakwaan
recited,
ketiga. Dua,
stating
membebaskan
that
terdakwa
defendant Fatia Mauliani has not been proven beyond a reasonable doubt to have committed the crimes in charges 1, 2, primary and the subsidiary charges, acquitting the defendant.
memulihkan hak terdakwa dalam kemampuan, kedudukan dan harkat serta martabatnya. 4, menetapkan agar barang bukti berupa barang bukti dari
Acquitting the defendant Fatia Mauliani of all charges, then returning their rights and their ability, their position, and their dignity and physical evidence.
Barang bukti nomor 16 dirampas untuk dimusnahkan.
Admitted into evidence number 1 to 14 in the case file, 15 through to
Barang bukti nomor 20 sampai dengan
will be seized for disposal.
67 dikembalikan
Number
kepada
17,
saudara
18,
Dedi
19
Barang bukti nomor 8
included in the
68
case file.
dengan
Physical evidence number 20 through to
bukti 88 dikembalikan
67 will be returned to Hedi Melissa.
Kemudian barang bukti nomor 89
Evidence number
terlambat
68
dalam
through
perkara.
to
Barang bukti nomor 90, 91 dikembalikan kepada
88 will be returned to Ray Partono.
dan 93
Evidence number 89 included in the case file.
sampai dengan 107
1991 returned to Paulus Parnanto. Physical evidence number 92 and 93 included in the case file. 94 through to 107 included in the case file. And evidence number 108 returned to the rightful owner. And evidence 109 will remain in the case file. The cost of the trial will be borne by the state. Thus, this verdict has been read by myself, Jokoda, as the head of the judging panel, Ali and Agil as members of the judging panel on Monday, 8th of January 2024. In this proceedings open to the public, with the support of Sulu Pikri and Sandi Handika as public prosecutor in the Eastern High Court, and the defendants as accompanied by their defense counsel.
Baik. Demikian dah. Tolong saja ya, ini belum selesai nih. Saya mau ngomong. Saya mau berbicara.
Okay.
Ya, baik demikian ya putusan terhadap
Very well.
Haris Azhar dan saudara
So that's it. Please remain orderly. I am still speaking. I wish to speak. So that was the verdict for Haris Azhar and Fatia Mauliani has been stated in this court. And now for the two defendants. Do you accept this ruling? Or would you like to, well, we have been acquitted because we have been acquitted, we accept this ruling. So you accept this ruling? We accept, Your Honor. Defense team, we as human beings, we have our flaws and we ask your forgiveness for any shortcomings. And so to the public prosecutors, to the defense teams, and the visitors, we thank you for maintaining order during this trial, which has taken over 8 months, and to ensure that the proceedings ran smoothly. That is all, and thank you. And that was the verdict. Ladies and gentlemen, please rise. Ladies and gentlemen, please take your seats.
Sorry mas.
Mas ya.
Ya, itulah. Kami ya, congratulations. Congrats Teras.
Keren ya Lex ya. Terus setia berjuang.
Kakak congrats ya. Congrats. Bagus ya, bagus ya. Sejarah. Sama.
Thank you dan selamat berkat dirimu. Ini berkat dirimu kok nggak ada yang lain.
Mas, makasih ya.
Selamat
buat Mas Lexi.
Kemenangan besar.
Mas, selamat Mas.
Tolong ini dicopotin Kak Dodi supaya aku bisa keluar. Terima kasih. Ya,
Ini internet ya.
terus dicopotin seperti ikutin aku ya.
Ini di bawah ini.
Ikutin aku aja.